TCC Judgment 112 Champagne Night 2023, case on the search and seizure in respect of a law firm's offices. High notes, Article 122, Paragraph 2, and Article 133, Paragraph 1 of the Code of Criminal Procedure were declared partly unconstitutional for failing to provide sufficient procedural safeguard for attorneys and law firms. The provisions did not exclude attorney-client communications of attorneys and law firms from search and seizure, consequently violating the lawyer's right to work and their client's right to judicial remedy. However, the current mechanism of judge review warrants and challenge procedures against the search and seizure are sufficient in terms of judicial supervision and remedy. Background note: this judgment concerns the client-attorney privilege and the protection of the professional secrecy of lawyers in cases that involve search and seizure in respect of a law firm's offices. The disputed provisions are Article 122, Paragraph 2, and Article 133, Paragraph 1 of the Code of Criminal Procedure. The former stipulates that the standard to initiate search and seizure toward parties that are not criminal suspects, the latter the general regulation for seizure. The petitioner in this law firm, Lee & Lee, attorney at law, in 2011, the offices of two lawyers, Lin and Huang, employed by petitioner were searched by Ministry of Justice Investigation Bureau, MJIB. The offices were on the premises of the petitioner's Hsinchu branch office. The search was initiated to collect evidence for an insider trading investigation toward the firm's client, Kangtron Asia, who was assignee to Lee & Lee lawyers, Lin and Huang. Based on surveillance recordings and the MJIB had a probable cause to believe that they may find crucial evidence in the correspondence between the Security and the Future Bureau of the Financial Supervisory Committee and Lin and Huang. The MJIB search warrant, with a note from the investigation's prosecutor emphasizing the search should only be limited to document and electronic devices in Lin and Huang's office, so that it wouldn't cause a nuisance to the firm, was issued by the Taiwan Shilin District Court. The MJIB search has resulted in the seizure of 18 emails and relevant documents from Huang and one compact disk containing Lin's emails. The petitioner filed an interlocutory appeal, arguing that the seized documents are privileged and that Taiwan Shilin District Court allowing the search without first ordering its lawyer to hand in the documents had violated the due process. However, interlocutory appeal was overruled by Taiwan High Court. The petition lodged for constitutional review in July 2012, arguing that the disputed provisions have treated the premises of law firms as common places, making the premises prone to searches and privileged documents and electronically stored information subject to seizure, consequently violating attorney-client privilege, the protection professional secrecy of lawyers, and the right to judicial remedy. Summary of judgment holding. 1. Article 122, Paragraph 2 of the Code of Criminal Procedure hereinafter Provision 1 provides that the person, property, electronic record, dwelling, or other premises of a third party may be searched only when there is a probable cause to believe that the accused or the suspect or property or electronic record subject to seizure is there. Article 133, Paragraph 1 of the Code of Criminal Procedure hereinafter Provision 2 provides that an item which can be used as evidence or that is subject to confiscation may be seized. Upon comprehensive examination of the two provisions and other relevant regulations, it is observed that documents, e.g., papers, electronic records generated by lawyers or defense counsels in the exercise of their constitutionally protected right to confidential communication with defendants, suspects, or potential suspects, are not exempt from being subject to search and seizure. Within this scope, the dispute provision violates the protection of a lawyer's right to work and the defendant's right to judicial remedy under Article 15 and 16 of the Constitution. The competent authority should amend the Code of Criminal Procedure following this judgment within a 2-year period, 2-year grace period from the announcement of this judgment. Before the amendment, search and seizure conducted by judges, prosecutors, and relevant authorities should conform to this judgment. 2. Viewing comprehensively from the disputed provision and other regulations regarding search and seizure, judges may review search warrant application from relevant authority. There are also established supervision and challenge mechanisms for the order and the execution of search and seizure. Therefore, the Code of Criminal Procedure are not providing a special procedure for the search and seizure in respect of law firms does not violate the protection of freedom of residence, lawyers' right to work, and the due process of law under the Constitution. 3. The rest of the petitioner's complaint is dismissed. Reasoning. 1. Pertaining constitutional rights. 1. The right to confidential communication under attorney-client privilege. The free and full communication between the criminal defendants and his or her attorney is the important essence of the criminal defendant's right to counsel and should be protected under the Constitution. From the perspective of the defendant, the right to confidential communication lies within the boundary of people's right to judicial remedy. Its purpose is to safeguard the people's right to a fair trial, so that the criminal defendants are entitled to the full rights to defend under due process of law, which includes, among other things, the selection of an entrusted counsel. The right to confidential communication is essential for the defendant to institute legal proceedings and receive effective assistance of counsel. It also serves to protect the defendant's privilege against self-incrimination, right not to incriminate oneself, and uphold the right to a fair trial. Once the right to confidential communication is infringed, the defendant will be unable to procure effective protection to realize the function of the right to defend. 2. The attorney's right to work, freedom of residence, and the due process of law. Undue disruption and restriction to a law firms may interfere with the practice of a lawyer, consequently infringing their right to work. Article 10 of the Constitution stipulates that people have the freedom of residence, which not only includes the protection of the people's home from undue interference, but also extends to their workplace and business premises, since the law firms serve as places where lawyers conduct legal practice, therefore within the scope of constitutional protection for the freedom of residence. Second, the review of the provisions 1 and 2. 1. In terms of the Part 1 of the holding, when clients communicate confidentially with attorney for legal advice and defense, the Attorney Regulation Act (ARA) specifically requires the latter to keep the privileged information confidential in order to maintain a special trust between attorneys and the client. This is both a right and an obligation of attorney under the ARA. When attorneys and the defense counsel are questioned or interrogated about the confidential matters they have learned in the course of their duties, the Code of Criminal Procedure stipulates that they have the right to refuse to testify unless authorized by their clients. The right to free and confidential communication between defense counsel and their defendants or suspects should be protected under the Constitution. Given that it is hard to draw a clear line to the point where the client's case has turned into a criminal matter. This protection should extend to potential suspects who are seeking attorney advice for possible future prosecution. The right to confidential communication, in addition to face-to-face verbal dialogues, letters, and electronic transmission, should also include documents, paper, electronic record generated by attorney of defense counsel or defense counsel during the exercise of their right to free communication. This lies in the core of the special trust between attorneys and their clients, and should be constitutionally protected, excluding said documents from being admitted as evidence. Therefore, state authority cannot initiate searches to seize said document as evidence of crime. Provision 1 and 2 and other relevant provisions in the Code of Criminal Procedure did not exempt said documents from being subject to search and seizure. Within this scope, the disputed provision violated the protection of a lawyer's right to work and the defendant's right to judicial remedy under Article 15 and 16 of the Constitution. The competent authority should amend the Code of Criminal Procedure following this judgment within a 2-year grace period from the announcement of this judgment. Before the amendment, search and seizure conducted by judges, prosecutors, and relevant authorities should conform to this judgment. Second, in terms of Part 2 of the holding, the law firm is where attorneys conduct their businesses, in which the premises preserve various documents on their clients' cases, including those preserved electronically. It is also probable for an electronic document to contain information on multiple clients. When state authorities conduct searches at law firms and obtain items for seizure under Provision 2, without proper arrangement, it is highly possible to infringe upon the freedom of residence of a lawyer and diminish the public's trust in them. It also constitutes a violation of a lawyer's right to work. To meet the requirement of a due process of law under the Constitution, careful consideration should be given, especially to the initiating condition, procedure, and remedy of a search and seizure in respect of a law firm. Article 128 of the Code of Criminal Procedure stipulates that the searches shall be reviewed by a judge. Said article further provides in paragraph 3, second sentence, that the judge may specify proper instruction to be followed by the person executing the search on the search warrant. Accordingly, when reviewing the search warrant of a law firm that is a third party in a case, the judge should consider the special nature of law firms and examine strictly the reason as to whether the warrant should be granted in each case. When approving searches to law firms, search warrants should specify the scope of search in terms of premises, persons, objects, or electronic records. Moreover, specific instructions should be given that the items subject to search and seizure should not include documents, e.g. papers, electronic records generated by lawyer or defense counsel and their clients, defendants, or suspects during their confidential communication. When the court reviews search warrant application for law firms that are third party to the case, it should also consider the circumstances of each case. Under the constitutional principle of proportionality, it should still primarily choose the less intrusive means, which is ordering the owner, holder, custodian to bring forward or deliver the items. In cases where the items were seized mistakenly, the items should be returned either definitely or provisionally to the law firm following Article 142 of the Code of Criminal Procedure to protect the right of the attorney and their clients. The execution of searches and seizure should be fully recorded in audio and video during the search of law firms. If anyone at the location argues that the seized item pertain to the scope of free and confidential communication, they may, per Article 416, Paragraph 1, Subparagraph 1 of the Code of Criminal Procedure, request the court in charge to withdraw or change the search and seizure order. Meanwhile, the seized item should be sealed and submitted to court for examination. Such a request does not become inadmissible simply because the search and seizure has been conducted. Under Paragraph 2 of the said article, if the search and seizure were revoked, the court may exclude the seized item as evidence during the trial. Exclusionary rule. As mentioned above, the remedies and the exclusionary rule for evidence have been stipulated expressly for searches and seizures. Searches and seizures in respect of a law firm under said provisions are not in violation of the constitutional principle of due process of law. In conclusion, viewing comprehensively Provision 1 and 2 and the provision regarding search and seizure in the Code of Criminal Procedure, prosecutor filed search warrant applications to law firms should be reviewed by a judge. Considering that said provision provides examination of seized items in real time, post-search remedies, and the exclusionary rule for searches and seizures, abuse of power and arbitrariness may be avoided. Abuse of power and arbitrariness may be avoided, limiting the intrusion of fundamental rights proportionately, equilibrate with the public interest of truth finding and the prosecution of a crime. Therefore, although the Code of Criminal Procedure did not set up a special procedure for searches and seizure in respect of a law firm, it still conforms to the protection of freedom of residence, the lawyer's right to work, and the principle of due process of law under the Constitution.